Questions in English. I'm going to talk today about wills and powers of attorney. The first thing that I want to discuss, which is probably the most important of all, is a word called capacity. And that relates to a person's ability to make a legal document. In the early days, there were different definitions of capacity. For example, doctors, when they determined capacity, they wanted to know if you could count backwards from 100, if you knew who the prime minister was. Questions that were rooted in space and time. For lawyers, we don't care about that. What we want to know is whether or not you understand the nature of your estate. If I'm interviewing a person to determine whether or not they have capacity to make a will or a power of attorney, I ask them about their house, their car, their investments. I want to know if they understand exactly what they have before we talk about how they will divide it up if they die, or if they want to choose someone to look after their matters for them. So our awareness of that issue, that thing called capacity, that is changing now. And I'm telling all of my clients, and I'll tell you here today, if you have someone in your family that is diagnosed with early onset Alzheimer's, PICS, any of those degenerative mental conditions, that doesn't mean that they can't make a will or a power of attorney right away, but it does mean that you should encourage them to see a lawyer, to determine whether or not they can, if they don't already have a will and a power of attorney, that they should look into getting it done. Just because a doctor diagnoses with a person with a medical condition, that doesn't mean that they're immediately incapable, they're unable to make a legal document. But the point is, and I've had situations where I literally have a client who is does not have enough capacity to make a will or a power of attorney, but they have a half an hour or an hour where they're lucid and they're good. Usually in the morning, they're better in the morning than they are in the afternoon. But I have made documents with people who otherwise don't have enough capacity during that one short period of time. And that's all you need, half an hour. And those documents can be signed and they'll be valid. The person is the attorney. So, if you make a power of attorney for financial, the person that you appoint has exactly the same powers as you do. You don't have any less powers, but that other person has the same powers. They can sell your house, they can draw money out of your bank account, they can make a mortgage, they can do all of those things. When you make a power of attorney for personal care with a health directive, that only kicks in when you're unable to make those decisions yourself. And the reason that it's done that way is because doctors and health professionals, they don't want the responsibility of making your decisions for you. If you're under anesthetic, or you're in a coma, or you have some other reason why you can't give instructions to a doctor or a nurse, they want somebody else. In the old days, we used to be next of kin, and you would put a note on the medical chart and so forth. But these days, they want a legal document. And so it's I never did a lot of them. I mean, I've been a lawyer for 40 years. I never did many of these powers of attorney in the first 10 or 20 years of my practice. It's only recently that these powers have come into use, and they are very useful. The PA for financial and the PA for personal care, there are different circumstances as well. person you appoint, and normally if it's your spouse, your stuff is all joined anyway. If it's not, it's your spouse that you would normally, your partner, that you would normally give that to. But otherwise, I've cautioned clients, sometimes clients want a son or a daughter or a nephew to have a power, to have a power of attorney for financial. But I tell people that they have to be aware, it's not the same. A lot of people think that power of attorney for financial, it doesn't kick in until you can't do those things yourself. That's not correct. The minute you sign that power, those people have that power. And it's exactly the same as yours. It's not any less. So what I do to help solve that problem is I put those original documents in an envelope in a file, or I tell my clients, put them in a safe deposit box and make sure that copies are not distributed unless and until you're ready to have that person use that power. And when I make the powers, I make 3 or 4 of each. People say, why do you make so many? Well, because everybody that sees that power, they want an original. They don't want you to explain that there's only one original. They don't care. Their rule book says you must have an original. So I just make 3 or 4 originals. And that way, and what I do is I give all of the originals but one to the clients. They take them with the appropriate explanation, and I keep an original in the file. And if for any reason they lose or they use up their originals, I can make certified, notarially certified copies, lawyer certified copies from the one original I have in my file. But the financial and the health powers are very different, not only in the way they're used, but in the reason that they're used. The people that you choose to be your attorney, they have different qualities. Someone that's going to have your power of attorney for personal care, those are people that are typically, you're very close to emotionally. They have, and it says right in the power, that they acknowledge that they have a concern for your welfare. They want to make sure that you are healthy and happy as much as possible. The financial power of attorney doesn't say that. And the reason it doesn't is because that person needs to be good with their own money, careful in their financial affairs, well organized. And that's the kind of person that you want to have in your family to do that particular job. But it's a very different job from being an attorney for personal care. Does that answer your question?
Yes, thank you.
No, it was a long answer.
That's very good. Can I follow up with one though?
Sorry?
Can I follow up with my question? Ask another one.
Absolutely.
So you made a PA for financials. I guess my basic question is, my understanding is wealth kicks in the minute I die.
The what?
The minute I die, the
Yes.
wealth kicks in, right?
Correct.
Okay. Can I make a PA for financials overlapping? No.
Absolutely
There
not.
we go. Answer.
There's a lot of gray areas in the law. That's not one of them.
No. Okay.
That PA, the law is different. There's a Lucy made a. The first one is a link to the Wills Act. The second one is a link to the Enduring Powers of Attorney Act. And the answer to your question is, the moment of death, different laws apply.
Mm-hmm.
So you cannot, you can't have a document that applies to a living person and have it apply to a dead person. Or I should say to their estate. That's the dividing line. And it's very important that people understand that. They're entirely different things. I have a will. And in some cases, that's not the end of the world, but the The big thing that I'll tell you right off the bat is important that you know is, if you die without a will, you don't have what we call a personal representative. You don't have an executor or an administrator. There's no one that can look after your estate. So if you die without a will, automatically your estate is going to have to be subject to a probate application. An application have to be made to the court to appoint an administrator to look after that estate, to wind up that. Go ahead.
Is the word estate means your personal property, physical property, financial assets? Is that what I mean?
Yes. You're very close.
Okay.
It means everything. Even property over which you may have an appointment. It doesn't necessarily have to be tangible property like money or your house or your car or whatever. It means everything. Your estate means anything that you have that has value in the world. And the wording in my wills and my powers often say specifically that the person you're appointing as an attorney has the power to manage any property you have anywhere in the world. So estate is a big word, and it includes everything that you have that has value. And some things that don't. I won't bore you with all of the details of the Devolution of Estates Act, but I will tell you the section that I'm talking about is called intestate succession. It's section 20, and the few that come in after that. And it's a very rigid kind of a scheme. You know, if you die and you have a widow and one child, your estate's divided this way. If you die and you have a widow and children, then your estate is divided this way. A portion to the widow, a portion to the children, regardless of how many there are. If you die and you have, if you die and you have no widow and no issue, it goes to the father or mother. If you don't have a father or mother, it goes to the niece or nephew. So it goes to the spouse, and then it goes to the children, and then it goes to mom and dad, and then it goes to nieces and nephews. And here's a lovely phrase. I enjoy it, and I've used it many times. It's called the lines of consanguinity, bloodlines. And that's how it's determined in the law. The person that's closest to you in blood, that's available if everybody else is gone, that's the person that gets the estate under the Devolution of Estates Act. So in many cases, this is not going to be a good method for dividing your estate. And as I say, when you compare that to the cost of a will, wills are going to range between $350 and $1,000, depending on the lawyer. But when you consider the value of your estate, isn't it important that you have the will done correctly? People say, oh, I can do a will, that's no problem. I can download it from the internet. We call them stationary wills. There used to be the Great Canadian Will Kit, guaranteed legal, $35. The document is legal, but that's never the problem with doing that kind of a will. The problem with doing that kind of a will is that people fill them out without legal training. And so there are lots of issues that arise. They don't sign it properly. You know, the little juror at the bottom of that will, it says, the person making the will, the testator or the testatrix, has signed the will in each page. And they've signed it in the presence of the two witnesses. And each witness has signed it in the presence of the other witness and the testator. And we're all present at the same time. And if you're not, your will's not valid. I made that mistake in the very first part of my practice. I signed one of my mentors, his client signed the will, and he had signed as a witness. Or no, I signed as a witness. And then but the other witness hadn't signed it, so I was going back to my office to carry on with my work, and he went, whoa, whoa, you need to stay here. until the other witness has signed. And that's where I understood the actual practical value of that requirement. And that's only one small rule. The other kinds of mistakes that people make, you know, I leave such and such to my children. Well, sometimes they have a child that is a stepchild. You know, we have blended families today. We have children that come from previous relationships. You know, if you just use the word children, it's unclear which children you're referring to. And so those kinds of issues are always what is considered automatically by the lawyer. I mean, I thought about that this morning. I've literally done hundreds and hundreds of wills over 40 years. And so, you know, that kind of procedure, you don't even think about it. You do it automatically because it's the law and you've done it so many times, like muscle memory, you know. So, when we do a will, the first paragraph of every will says, I hereby revoke all other wills. Crucial. You've got to have that. You can't have a situation where any other documents that you've made before can have any effect, because obviously there could be a conflict. I hereby revoke every will, every other document I've made. The second paragraph deals with executors. As I said earlier, if it's a husband and wife team, the other spouse is the first executor. But the second, the alternate, if that spouse can't do what they need to do, they're unable or unwilling, then you have an alternate executor. What I tell my clients is, in a perfect world, there'll be three things. They'll be young, over 19 of course, but young. They'll be geographically nearby, because that's a hands-on job. They gotta clean out the basement and the garage, and they gotta do all of that kind of stuff. And if they're in Vancouver, it's a lot more difficult. Third, they need to be well organized in their personal affairs. You know, we all know, some of our kids are, some of our kids aren't. So, you use those three rules, and you move, when you're looking at people in your family to be an executor, an alternate executor, you move away from that rule as little as possible. Young, close geographically, and well organized in their personal affairs. That's a rule of thumb when you're choosing an executor. The next paragraph is a series of paragraphs. It's a lot of gobbledygook. It's designed to give power to the executor to deal with the estate. Power to sell, call in, convert into shares, mortgage, you know, all of the words that lawyers love to use to describe everything. And then at the end, there is a distribution. Now, sometimes there's specific requests. I leave any car that I may have at the time of my death to my nephew. But your estate, normally, once we've dealt with a specific request, you leave $5,000 to a niece or a grandson, and all of the debts and the funeral and testamentary expenses are paid. What's left is the residue of the estate. And so then you decide how that residue is divided. If it's divided equally between your three children, that's fine. Another thing that you need to be aware of is that your will needs to look fair on the surface. An equal distribution of what's left to your children is a common thing, and it's very well accepted. Go ahead. So, you know, I mean, I know that the law, you're not going to see the Wills Act in China that's the same as it is in New Brunswick, but the concept's the same. You have these things, and they have to be divided, and they have to know who they're going to go to. So I wouldn't expect that would be, I'd be interested to see how that works out. I bet you that you could have a will in Chinese with a Chinese lawyer that says exactly the same thing as your will in New Brunswick.
So you only can cover how many
No, that's not what, no, that's not, I don't know that that's correct. I would make, it's the same thing as being presumed to have capacity. If you have property in other places in the world, I would put that in your will. And I would expect that that would be obeyed unless there's some law or some reason. I mean, more likely what I would see is that there are additional fees that would have to be paid in order for that will to be recognized in China or in Vietnam or Italy or whatever. But I would be very surprised if it would be changed. You might pay a little bit more to have it, and I don't know, again, here you register the will to transfer property. In China, I don't know. I would assume you'd have to have some process of registration in order for the government to recognize it. But I would, there's no question that I would include any property anywhere in the world, and if there's property that is not here, I would be more inclined to be very careful about identifying it in the will. Where it is, what it is, if you've got any kind of a value or anything like that. I put a provision in my wills that says that there's no requirement. If you've got a son or a daughter that's looking after your estate, there's no need for them to post a bond. Here, there's a rule that says you've got to post a bond as security if you want to administer somebody's estate. I put a word right in the will that says no need for that.
So for husband and wife make a wills, are they make a joint or make a separate? Maybe identical but separate. What's the kind of that?
They're not identical, but mutual.
Mm-hmm.
But yes, definitely two different documents. Executed separately. And you know, it's funny you should mention that. I've had situations where a husband and wife came in to make their wills, their mutual wills, and the guy gave me some instructions, and then he had to go out to the car to get something out of the glove compartment, a driver's license or something. And as soon as he left the office, she started crying. And she proceeded to tell me that she didn't agree with it, and she didn't want to do this and that, but she was too afraid to say anything. Sometimes it happens. I always watch for that. It doesn't happen very often. It's very rare. But, you know, and usually if you make a mutual will, the provision that can be made is a brand new statute. I have to look at it because I can't remember all the words. It's called the Supported Decision-Making and Representation Act. And it's been around for a little over a year, and the lawyers hate it because nobody knows anything about it. I just did one recently, and it was a very long process. And I was very lucky. We got an order pretty quickly. But it requires a functional capacity assessment, a 4-page document by a doctor, that have a social worker involved, and you got to fill out some long affidavits, but they're very reasonable. You know, they're the biggest one is the one of the person's going to be looking after, usually the mother or the father. And there's different degrees. You know, you don't have to have a complete order. You can have an order that says you only need to help them with certain parts of their lifestyle or their legal responsibilities. So it's easier, but it's still complicated. It's not as bad as it was before. But and so the point is, if you've got anybody that's heading towards dementia or not having capacity, they should be signing documents as soon as possible. Nowadays, to do a power of attorney, you have to have a lawyer. You didn't have to have before. You were able to do one on your own, but now you have to have one. And it's a good thing because there are certain rules that you have to follow, and lots of times people didn't follow them when they did their own powers of attorney.